Friends, today I am taking up Law of Contract to Specific Contract under Indian Contract Act 1872. I am taking major sections and their key points, and many of the questions are asked on the basis of these sections. So I am going to discuss all the topics under this law of contract to under specific contract. So let us start. Unit 1, Indemnity and Guarantee. It is covered under section 124 to 147. Now, section 124, Contract of Indemnity. It says a promise by one party called indemnifier to save the other party indemnified from loss caused by the conduct of a third person or by the conduct of the indemnifier himself. For example, insurance policy. Coming to section 125, rights of indemnity holder. What are the rights? The indemnity holder, while acting within his rights, can recover from the promisor all losses, legal costs, and amount paid in the settlements, provided he has acted in accordance with the promisor's instructions and in a prudent manner. Section 126, Contract of Guarantee. What is this? A promise by one party, the surety, to pay the lender, creditor, in case a third party, the principal debtor, defaults. There are three parties involved: the creditor, the principal debtor, and the surety. Example, a guarantee given by a friend when taking a loan from a bank. So, bank is the principal debtor and loan taking man is the creditor and surety is the friend. So, this section says about contract of guarantee. Now coming to section 129, continuing guarantee. Guarantee applicable to a series of transactions. Single person can take guarantee of series of transactions. Section 130, revocation of continuing guarantee. When a guarantee can be revoked, the surety can revoke a continuing guarantee at any time by informing the creditor, but remains liable for transactions made before revocation. For example, if a guarantees C for future bills but revokes it after 3 months, A will only be liable for bills due before revocation, not after. Section 132 to 139 deal with surety's liability and rights. Now, rights against the principal debtor. When the surety makes payment to the creditor, he acquires the following rights against the debtor. It is covered under section 140, 141, 145 and 147. Now coming to section 141, rights to securities. The surety is entitled to the benefit from all securities held by the creditor at the time when the guarantee contract was made. If the creditor loses or returns any such security without the surety's consent, the surety is discharged to the extent of the value of that security. Now section 145, right of indemnity. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. The surety is entitled to recover all amounts that he has properly paid under the guarantee. Section 147. Section 147 of the Indian Contract Act 1872 relates to the liability of co-sureties. Suppose there are different sureties for one debt who promise to guarantee a debt or duty for different amounts. Essentially, if there are three sureties A, B, C, guarantee different sums, and the principal debtor fails to pay, suppose he fails to pay the loan, they share liability equally within their specified limits, ensuring fairness among them. Now, key provisions of section 147, equal share. When there is equal share, in the absence of any agreement to the contrary, co-sureties are responsible for paying equal shares of the debt. Different sums, different shares, when sureties are bound for different sums. For example, 10,000 for A, 20,000 for B, and 40,000 for C. Their liability is confined within those limits. It is divided proportionally. Now coming to Unit 2 of Law of Contract. Bailment and pledge. Bailment is covered under section 148 to 171 and pledge is covered under sections 171 to 181. Now, what is the definition of bailment? It is given under section 148. Bailment occurs when one person, called bailer, delivers a material to another person called the bailee for a specific purpose. The contract is that after the purpose is accomplished, the material will be returned or dealt with according to the bailer's direction. Means the material after completion will be returned to the bailer. For example, giving your watch to a mechanic for repair. When the mechanic repairs the watch, you give back the same. Now coming to section 150. Duties of a bailer. What are the duties of a bailer? Disclosure of defects. The bailer must inform the bailee of any defects in the material known to him which may prevent its use. If he does not disclose it, then it may prevent its use. Failure to do so renders him liable for any resulting loss. Section 158. Payment for necessary expenses. If the bailment is gratuitous, without any payment, the bailer must pay all necessary expenses incurred by the bailee for the safety and maintenance of the material. If there is no agreement for any expenses to be incurred, then in that case, whatever expenses on the part of the bailee, the bailer has to pay. Section 159. Compensation for early return. If the bailer requests the goods back before the agreed time and the bailee suffers any loss as a result, the bailer must compensate that loss. Return of goods. When the object is returned upon fulfillment of the purpose, it is the bailer's duty to accept it. Now coming to section 164. Compensation for defective title. If the bailer did not have the right to deliver the goods and the bailee suffers any loss as a result, the bailer shall compensate for it. Now coming to pledge. I was discussing bailment. Now I am discussing pledge. Section 172. Definition of a pledge. What is a pledge? A pledge is the delivery of property or goods as security for a loan. The person who pledges his property or goods in exchange of a loan is called the pawner, and the person to whom the property or goods are pledged is called the pawnee. 173 states about right of retention of the pawnee. The pawnee can retain possession of the pledged goods until the loan or promise made, including interest, is fulfilled. Section 174. Duty of the pawnee is not to use the goods. Section 176. If the pawner defaults, the pawnee has two options. Number A, file a lawsuit against the pawner, and second, he can sell the goods. But before selling the pledged goods, give the pawner proper notice of the sale. He has to inform the pawner. Section 177. The pawner may place additional goods to the extent of his interest. These sections establish the rights and obligations in the pledge transaction, which are important for providing secured loans using movable property. Now, what is the difference between bailment and pledge? Bailment is a broad term which means handing over goods temporarily for a specific purpose such as repair or storage, whereas pledge is a narrower type of bailment in which goods are given as a security for a loan only, giving the recipient the right to sell the goods if the borrower fails to pay. Now, main difference actually is a bailment has multiple purposes, whereas a pledge is only for securing a loan. In a pledge, the pledger can sell the goods if the payment is not made, whereas a bailer usually cannot do so. The main difference is that all pledged items are bailment, but not all bailments are pledges. The fundamental difference lies in the purpose and the right to sell the goods in case of default, which exists only in case of a pledge. Now coming to your third, agency. Section 182 to 238 of the Indian Contract Act 1872. Section 182 to 238 relate the contracts of agency, which define the agent, the principal, the right, duty, and responsibility. These sections detail the appointment of an agent, his scope of authority, principal's liability, agent's personal responsibility, and the methods terminating his work, providing a legal framework for a person to act or represent another. Now, duties of an agent. Section 190. He cannot delegate his powers. An agent cannot assign his work to someone else. Section 211. Compliance with instruction. He has to act according to the instructions of his principal. Section 213. Accounting. He has to present accurate accounts when requested by the principal. Section 216. Not to make personal profit. He cannot make his personal profit, not to make secret profit without disclosure, and to avoid conflicts of interest. Now, what are the rights of the agent? It is covered under section 219. Right to remuneration. The right to receive reasonable or agreed remuneration. Section 221, right to abolition, the right to retain the principal's property or document until payment is made. Section 222, right to indemnity, to be compensated for losses incurred during legal acts. Section 225, right to compensation, to receive compensation for injury or loss due to the principal's negligence. Now, coming to creation of an agency. Section 182. An agency can be created in the following ways. Express agreement, when authority is given through written or spoken words, that is power of attorney. Implied agreement, when circumstances, conduct, or customary business practices indicate agency. By ratification, when a person acts without authority but later the principal ratifies that act. By necessity, an act done to protect someone's interest in the emergency situation when it is impossible to contact the principal creates an urgency. By estoppel, if the principal by his behavior induces a third party to believe that a person is his agent, he cannot later deny it. Now, termination of agency. It is given in section 201. An agency can be terminated in two ways. A. By the actions of the parties. Mutual consent. Both parties agree to terminate the agency. Revocation by the principal. The principal withdraws the agent's authority. Resignation by the agent. The agent gives notice of leaving the work. Secondly, by operation of law. Completion of work. The work for which the agency was created is completed. Expiration of time. If the agency was for a fixed period, death or insanity. In the event of death or mental incapacity of either the principal or the agent. Insolvency. If the principal is declared bankrupt. Destruction of the subject matter. If the object for which the agency was created is destroyed. Now, liabilities toward third parties is under sections 226 to 238. Section 237. If the owner has represented by his conduct that a person is his agent, he will be bound by this person's action. Estoppel. Section 238. Any fraud or misrepresentation committed by the agent will have the same effect if it had been committed by the owner. Now, coming to Unit 4. Government contract, constitutional provisions, kinds of government contracts, performance of government contracts, settlement of disputes and remedies. The general principles of government contracts in India are governed by the Indian Contract Act 1872, but strict adherence to Article 299 of the Indian Constitution is mandatory, according to which they must be in written form, expressed in the name of the President of the Governor, and executed by authorized officials so that they are legally enforceable. Whereas ordinary contracts may be oral or implied. These constitutional formalities ensure the transparent use of public funds, subjecting government contracts to high scrutiny and specific procedural rules. Key requirements for government contracts. Article 299. Expressed in writing. It must be a formal written agreement, not oral. It should be in the name of the President of the Governor. The contract must clearly state that it is made on behalf of the Union of India or the state government, executed by authorized person. It must be executed by authorized person, meaning signed by a duly authorized official in accordance with the rules specified by the President or Governor. Now, common types of contracts. Fixed price contracts. A single predetermined price for the entire project, with the contractor bearing any additional cost increment. Cost reimbursement contract. The contractor is paid the actual cost along with an additional fee. Profit. The buyer has to bear more of the cost, the additional cost. Time and material, T&M contracts. Payment is made for direct labor hours at agreed rates along with the cost of materials, often with a maximum price limit. Indefinite delivery oblique indefinite quantity, IDIQ. This applies when the exact quantity of the contract is unknown, allowing the government to order goods as needed over a specified period. Now, settlement of disputes. Most government contracts require a multi-tiered approach to dispute resolution, which often begins with informal methods before reaching formal adjudication. Alternative dispute resolution methods are generally preferred due to their speed, confidentiality, and ability to preserve business relationships. Now, negotiation. The first step is usually direct negotiation between the government contracting officers and the contractor to resolve the dispute without third party involvement. Mediation and conciliation. These are the ADR methods. Mediation and conciliation. An impartial third party helps the disputing party reach a resolution by mutual agreement. These processes are voluntary and non-binding. And if the parties agree, the settlement can be recorded as a binding mediation decision. Now coming to arbitration. It is a common method in which parties agree to present their dispute before an impartial third party known as arbitrator. There may be a panel of arbitrators also who delivers a binding decision, arbitral award. Contracts often include a specific arbitration clause detailing the procedure and the agreed arbitrator. Now, dispute review boards, DRBs, and adjudication boards. These are often used in large infrastructure contracts to provide timely interim relief and recommendation for disputes arising during the project life cycle. Judicial process. Disputes can ultimately be resolved through legal proceedings in civil courts, although most contracts prefer arbitration to avoid lengthy court battles. Legal proceedings remain an option, particularly if the dispute involves questions pertaining to public law or constitutional violations. Now, remedies. What are the remedies? Compensatory damages. Monetary compensation given to the non-breaching party to restore him to the financial position he would have been if the contract had been performed. Liquidated damage, a specific predetermined amount fixed in the contract which is payable in the event of a breach of the contract. Nominal damage, these are awarded when a breach has occurred, but no significant financial loss can be proven. So friends, these are all about the section of the law of contract. Hope you will find very interesting, and on the basis of these sections, many university questions are asked. So just remember it. Thanks for watching this video.